Well-known rapper Young Thug, real name Jeffrey Williams, was indicted on May 9, 2022 in Fulton County, Georgia. The charges came under the state's anti-racketeering law, and a re-indictment followed on August 8, 2022. Prosecutors claim Williams led a violent street gang called YSL, short for Young Slime Life. They say it operated under the name of his record label, Young Stoner Life. The charges? Conspiracy, gang activity, plus multiple gun and drug offenses. The case headed to jury trial, and on Friday, June 7, 2024, a dramatic moment unfolded in court. Fulton County Superior Court Chief Judge Ural Glanville, who's overseeing the case, found one of the state's witnesses in contempt. The witness refused to testify, invoking the Fifth Amendment, even after being granted immunity. Judge Glanville ordered the witness jailed until Monday, June 10th, giving him time to reconsider. Then, on the morning of June 10th, something unexpected happened behind closed doors. In his private chambers, Judge Glanville met with prosecutor Adrian Love, the witness, and the witness's attorney. A court reporter transcribed the conversation. By the end of it, the witness agreed to testify. But there's a problem. Defense attorneys for Young Thug and his co-defendants weren't told about the meeting. They weren't in the room. They didn't even know what happened. This type of meeting is called an ex parte communication, when a judge talks with one side of a case without the other side present. And under Rule 2.9 of Georgia's Judicial Conduct Code, judges are strictly barred from allowing or initiating such contact unless a very narrow exception applies. Later, someone, we still don't know who, tipped off the defense. At an open court, one of Young Thug's attorneys, Brian Steele, stood up and brought the issue directly to Judge Glanville's attention, putting it all on the record.
The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never...
Mr. Steele, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too, and the reason
I'm asking you a question. How did you find out about it?
I'm going to ask you the question.
Okay.
Scuttle, if you look at SCUDDER versus State, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me and you and Mr. Adams meet with me and others have met with me. it's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of the record.
Well, I'm going forward. What I was told was that Mr. Copeland said...
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to...
No. I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information...
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have... I have problems right now.
Okay, I know. Look, I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
yes. A witness who was sworn in Friday, the court's telling, this is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it proprietary?
Or information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why?
Sir, I'm going to hold you in contempt if you don't tell me who tell me who this information was coming from.
I don't want to be held in contempt. Well, I'm not answering that question. That's attorney-client privilege information. I am not answering
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out. I tell you what, I'm going to give you 5 minutes. If you don't tell me who if you don't tell me who it is, I'm going to put you in, I'm going to put you in contempt, because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes?
This is what I was told. Mr. Copeland made statements.
Judge Glenville turns to Mr. Steele, asking how he found out about the ex parte meeting. But Mr. Steele refuses to answer, firmly citing attorney-client privilege. The courtroom falls silent. Then Judge Glenville calls for a 5-minute recess and warns Mr. Steele that if he doesn't reveal his source when they return, he'll be held in contempt. Under Rule 1.6 of the Georgia Rules of Professional Conduct, attorneys must keep all information from their client relationships strictly confidential. The rule's commentary explains this duty covers not only what clients say in private, but any information learned through the professional relationship, no matter where it came from. Still, there's one exception. Rule 1.6 allows disclosure if a court order demands it. When the recess ends, Judge Glenville returns to the bench. The tension is thick as he calls Mr. Steele back to the podium.
Okay, Mr. Steele, would you take the podium, please, sir? All right. All right. Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy. But as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know
lies.
what the rule says, but here's the thing.
Well, let me just.
You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah. And that's why I raised it. It is that serious that we should have been there and it shouldn't have happened.
Sir, that's a whole separate issue. And that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is how did you get this information?
I understand the issue. I promise you I understand it. But what I'm trying to ask you is if you look at Common 5, this is how I understand the law.
You can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get the information?
But just listen to what I'm trying to tell you. You're threatening me with contempt.
The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you. I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, you're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not substance, but I'm telling you I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
You can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time. And I'm not going to breach that confidence.
I don't want to hold you in contempt, but this is that serious.
Judge,
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Mr. Steele once again refuses to reveal how he found out about the ex parte meeting. Judge Glenville, clearly running out of patience, holds him in contempt, giving him until 5 p.m. to disclose his source. Judge Glenville insists he isn't asking for confidential client details, just an explanation of how Steele obtained that information. But Mr. Steele stands firm. He argues that even revealing his source would break his ethical duty under Rule 1.6, which requires him to keep all client-related information strictly confidential.
Judge, listen, I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing. I'm moving for a mistrial. It is my understanding, based upon information belief,
from whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we can.
Okay, well, then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
Well, then, other than if you were sitting, unless you were sitting in there with a recorder or Miss Love or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that as a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking about?
But anyways, I'm not going to have
When I got this information.
I'm not going to have any further conversation with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence. That's really it.
He can go into custody at this point in time.
I think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with a witness outside of our presence.
And whenever, yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness based upon information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay,
why
that's for another day.
In the first place, I didn't know about this stuff.
That's for another day. So
I raised it as soon as we found out about it.
Well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2. That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele, that is not that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know, that I'm not telling you. I'm just saying if you read I'm assuming you read it. That's what it says.
Mr. Steele moves for a mistrial, claiming Judge Glanville held a secret ex parte meeting with a witness. A mistrial means the trial ends before any verdict, usually because something has happened that makes a fair proceeding impossible. When that happens, the case can be retried before a new jury, unless double jeopardy or another legal rule prevents it. As the Supreme Court of Georgia explained in the 2016 case of Scudder versus Georgia, a criminal defendant has the right to be present at every critical part of their trial. However, that right can be given up or waived if the defendant or their lawyer chooses not to exercise it. In the Scudder case, the defendant argued it was wrong for the judge to meet privately with a witness. But the court disagreed. The judge had already announced his plan to speak with the witness in open court, and since neither the defendant nor his lawyer objected, they effectively waived that right. Here, though, the situation is different. Judge Glenville's meeting with the witness happened in secret. The defendants weren't told, weren't invited, and never had the chance to attend or waive their right to be there. That's why Mr. Steele and the defense team believe this private meeting may have violated the defendant's constitutional right to be present during every critical stage of their trials.
And you did it supposedly.
Does the state wish to be heard?
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
You can't hide behind, yeah, but the thing is, I think you got this information, somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or that a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
Well,
why aren't we
that leads to be told. But
right now, We don't know
Mr. Steele.
why we were excluded from that.
Mr. Steele,
and I want that information
stop.
because
Just
Mr.
stop.
Williams' constitutional right on the
Just stop.
Georgia Constitution.
Just stop at this point in time, because
Article 1, Section 1,
because
paragraph 12.
you've already said that. You've already said
Georgia
that.
Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, madam, Ms. Love.
And Your Honor, excuse me. And I know I said this previously.
Yes, sir.
But we are not accepting any proffer from Ms. Love.
Okay, excuse me.
Okay. All right.
To the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within an ex parte conversation. Not only was there an ex parte communication between that we requested as a state to be on record with the court, but there was communication made, I believe, to a person and his lawyer. I don't know that the reason that counsel took the podium was to address that particular issue so much as it was to try and assert an inaccurate what he calls fact and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive.
Ms. Love argues that the defense had no right to attend the ex parte meeting because it dealt solely with the civil contempt order placed on the witness. Civil contempt proceedings, she notes, are technically separate from the main criminal trial. That means Judge Glenville could have addressed the contempt issue directly with the witness and his attorney, without the criminal defendants or their counsel present, since their liberty wasn't at risk at that point. But here's where it gets complicated. Even if this contempt issue was technically civil, the meeting had a direct impact on the criminal trial because it led to the witness agreeing to testify for the state. As we mentioned earlier, judges are strictly prohibited from having ex parte discussions about substantive matters in an ongoing case. So, Mr. Steele's argument that the defendant's rights were violated during that private meeting carries significant weight, even though it centered on the contempt order. After denying multiple mistrial motions from the other defense attorneys, Judge Glenville turns his attention back to Mr. Steele.
Okay, Mr. Steele, last time, who told you? All right, Mr. Steele's in custody. And once he clears the area, we'll go ahead and get started.
If by that point means we'll get started and resume the trial, Your Honor.
Yeah, we're going to continue. I'm not caught nothing.
I'm not going to participate in the trial without the Steele and without
You don't have that luxury at this point in time, sir. You don't.
without the court addressing
You don't have that luxury. You don't have that luxury at this point in time. You don't.
without the court addressing the issue that we believe is germane to the
Sir, you all are really getting yourselves cross purposes at this point in time.
I don't believe so.
Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now.
Respectfully, I will not.
Say again?
Respectfully, I will not. I cannot.
Sir,
Technically, I
you have to.
feel as though I can properly represent Mr. Williams
Well,
until
you-
this issue is
You're gonna have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time, sir. Yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly, sir. I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was given, said, whatever, this morning that.
If there is any accuracy to some of the information that we are.
But sir, I don't even know. Your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No. It's not, sir. Sir. That's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been, and the only. Okay, well then no, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir.
After Mr. Steele refused to reveal how he learned about the ex parte meeting, Judge Glenville found him in criminal contempt. Deputies were ordered to take him into custody, and right in the middle of the trial, Mr. Steele was briefly removed from the courtroom. Later that same day, however, Judge Glenville allowed him to return, explaining that he didn't want to deprive Mr. Williams of his chosen attorney. Instead, the judge sentenced Mr. Steele to 20 days in jail to be served on weekends so he could still represent his client during the week. In a rare move, Mr. Steele asked to serve his sentence in the same facility where Mr. Williams was being held, hoping they could continue preparing for trial together. But after the sentencing, Mr. Steele quickly sought appellate relief. The Georgia Supreme Court granted an emergency stay, pausing enforcement of the sentence while it was under review. Then, in October 2024, the High Court reversed the contempt order entirely, ruling that Judge Glenville should have recused himself from the matter since he was personally involved in the dispute. As a result, Mr. Steele never served any of the jail time he'd been given. And on July 15, 2024, Fulton County Judge Rachel Krause formally removed Judge Glenville from the case following recusal motions filed by defense counsel. Judge Paige Reese Whitaker was then assigned to take over the trial. On October 31, 2024, Mr. Williams entered guilty pleas to 1 gang charge, 3 drug charges, and 2 firearm charges, along with no contest pleas to another gang charge and a racketeering conspiracy charge. He was sentenced to 40 years, with most of that time suspended. His initial 5-year prison term was credited as time served, and he was placed on 15 years of probation. If Mr. Williams violates any probation terms, he could still face up to 20 years behind bars. This entire episode reveals a deeper tension within the justice system, the struggle between judicial authority and the ethical duties of defense counsel. Judge Glenville acted to assert control and demand answers, while Mr. Steele stood firm, protecting confidential information as required by professional conduct rules. The confrontation also underscores why ex parte meetings are so tightly restricted. Even when nothing improper happens, they can create the perception that one side has gained an unfair advantage. By prohibiting such communications, the law safeguards public trust in the court's impartiality. In the end, this case shows how the legal system constantly walks a fine line, balancing judicial power, attorney ethics, and the need to ensure both fairness and the appearance of fairness. Let us know in the comments which courtroom moment or case you'd like us to cover next. Thanks for watching, and don't forget to subscribe and share to help build a more informed society.